one judge on the 11th Circuit made some news earlier this summer in a concurrence. Judge Kevin Newsom, I think Kevin is his first name. I hope I got that right. And he used ChatGPT to try and determine ordinary meaning in a statutory interpretation case. Can you walk us through what Judge Newsom did there and why it got so much attention?
Sure. So the case was an insurance dispute, and the ultimate holding or part of the holding hinged on whether an in-ground trampoline qualified as landscaping under the insurance law at issue. And Judge Newsom was consulting dictionaries, working with his law clerks, trying to figure out if a trampoline would be considered landscaping, and couldn't find a definition or an understanding of the trampoline that was helpful. So he's sort of in jest, and he talks all about this in the concurrence, which is lengthy, about how he came to consult ChatGPT, but he actually found ChatGPT to be particularly helpful in resolving the question. And what he actually asked ChatGPT was, could an in-ground trampoline be considered landscaping? And the AI answered that yes, this is a quote, yes, installing an in-ground trampoline can be considered a part of landscaping. It's a deliberate change to the outdoor environment, often aimed at enhancing the overall landscape and usability of the area, end quote. So that is the response that he got from ChatGPT. And he talks about this in the concurrence and how helpful it was and how he viewed it to be a more comprehensive version of how this word would be used in common parlance. And that's something that he prioritizes in his opinions. So it caused a lot of buzz. He was very transparent with his use of ChatGPT, and he also shared the prompts and the responses in his concurrence. And of course, it stoked a lot of conversation across the profession, and a few outlets, law.com in particular, surveyed some other judges who are at the cutting edge of using technology and asked them for their thoughts. And the thoughts ranged from really celebratory and commending Judge Newsom for being so forward thinking and showing the profession how it could be used, to other judges who were less certain that LLMs are appropriate, in part because of the biased data underlying their training sources, and in part because of the limitations and the hallucinations that LLMs can produce. So I will tee it all up, but I have no experience being a judge. You have tons of experience being a judge. So I'm curious what your reaction was to Judge Newsom's approach here and some of the responses across the judiciary.
Yeah, I thought it was fascinating. I'm really glad he did it and started the conversation. I feel like it was an important conversation starter, not only about the ways that this technology might be useful in helping figure out ordinary meaning of terms in regulations or statutes or even constitutional text, but more than that, how judges think about those subjects. I mean, you read a lot of judicial opinions where there'll be a majority opinion and a dissent, and both sides of the opinion are super confident that they have determined the correct meaning of a particular word. And it always seemed to me like, obviously, it's a really hard question if really smart people who have the same training are coming to different conclusions about what this particular term means. And one carries because it's a majority rule industry, but obviously, it's the tools that judges have are imperfect, right? So dictionaries is a typical one judges look to, and there are lots of critiques by scholars that judges can cherry pick dictionaries depending on the particular outcome they're looking for. I'm not saying that those are fair critiques. I'm saying that those are critiques that you hear pretty regularly. And I think that if you asked people who didn't go to law school to read a judicial opinion, and where dictionaries were used to define a term that people sort of had an intuitive sense of what the term meant, they would be scratching their head, and they might say, well, we kind of know what that means, and here's what it means. And this Judge Newsom's use of the technology felt to me like the kind of opinion that a person reading it who didn't go to law school might say, yeah, that actually makes sense. And I can accept that decision because it actually rings true with me. It evokes this earlier. There was like sort of, I don't know, 5 to 7 years ago. There was this move by a number of courts, and the Michigan Supreme Court was one of them. In an opinion drafted by one of my colleagues, Justice Brian Zara, where courts were using corpus linguistics, which is a method of linguistic analysis that uses large collections of texts, not legal texts, just texts, called corpora to study patterns and usage and structure of language. In a way, I feel like corpus linguistics in judicial decision making was the precursor to ChatGPT in judicial decision making. There's some important distinctions. The texts that are in corpora are knowable, so it's totally transparent. Unlike we don't know all the training data in LLMs, and obviously the technology is different. It's statistical analysis in corpora and it's neural networks in LLMs. But there were, in addition to the Michigan Supreme Court, the Utah Supreme Court issued at least one, but I think more than one opinion using corpus linguistics, and Justice Breyer did it in one opinion. I think the thinking there was, it's a bigger set of texts to help figure out what a particular term means, and we can actually, by looking at the way normal people were using language in whatever the relevant period was when a particular statute was passed, we can get closer to what ordinary people would have understood the term to mean. And I was persuaded that it was a useful tool at that time. And so I think I'm similarly persuaded that this technology is at least another tool that judges could, and in some cases probably should use transparently, again, telling their readers and colleagues what they used and what their prompts were, to help understand terms that are not perfectly clear. I don't know. It'll be interesting to see if other judges take up Judge Newsom's invitation. I think that's how I read it, was an invitation to start at least thinking about the ways in which this technology might help us with understanding ordinary meaning.
Yeah, I had not been familiar with that movement, so thank you for introducing it because it does sound very similar. It sounds a little bit like a slightly more laborious way to do it, but like you said, a little bit more transparent, but similar to LLMs. It's really quite fascinating.
Yeah, I have to. It's all gonna get more and more interesting too. I do think that the ways in which these LLMs can make decisions is going to be something we're all going to be continuing to talk about. I think I don't know if I mentioned this to you, but so many now appellate section educational programs are focused on this topic of when is it appropriate for generative AI to be used by courts and by judges. And so I think it's a topic that we're gonna this is not going to be our final episode on this topic. I feel like we'll be coming back to this one. And I recently got to talk to Adam Unikowski, who is a partner at Jenner and writes a really interesting newsletter that I encourage people to go look at. And he fed on this topic of he's an appellate litigator, like a fancy one. He practices in the U.S. Supreme Court. He practices in federal appellate courts and state Supreme Courts. Full disclosure, he appeared before me once in the Michigan Supreme Court, although I didn't remember that when I talked to him about his work. In this context, he reminded me afterwards, and he did a great job. But he did a great experiment, a really interesting experiment, where he fed all of the merits briefs from all of the cases argued in the U.S. Supreme Court this term into Claude Opus. That was the most advanced model when he did his experiment. And he asked Claude to write a 3-paragraph opinion deciding each case. And in almost every case, it 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 wrote an opinion consistent with the way the U.S. Supreme Court decided the case, and it did an excellent job. In a few cases where it didn't write an opinion consistent with the U.S. Supreme Court, Adam himself was persuaded by Claude's opinion more so than the U.S. Supreme Court's opinion, and there were cases where it was a close question and justices disagreed. But what was even more interesting was he went beyond that and then asked Claude to come up with a different solution to a particular legal problem in a particular case that neither party suggested. He said, we come up with another way, a new test that neither party suggested for how we could decide this hard legal question. And it's fascinating what Claude came up with. And Adam Unikowski, who again is like a very accomplished appellate lawyer, said, Claude is absolutely capable of doing the work of, the fanciest appellate law clerks we have right now, and maybe even a justice. So, that's not saying that it doesn't still have some of the problems we've talked about many times in the course of this podcast. But it is a stunning experiment he ran very quickly, very easily, that really tells me there are going to be more and more uses for this technology for courts, for arbitrators, for mediators, for anybody trying to come up with creative solutions for problems that people, organizations, and businesses are facing. It's going to open up all kinds of new possibilities, which I think is a really hopeful thing. I'm excited about it.
That's really cool. And I mean, it's one of the use cases now that's already live and ready to deploy is its persuasive ability. And I've had this experience too outside of crafting judicial opinions, which I don't do for fun or otherwise, but I've had it sort of like help me through some interpersonal dynamics where I'm trying to write an email or come up with a solution. And it will sort of create an argument, or not even an argument, it's not a dispute, but a position and a perspective that I hadn't thought of before. Because it's sort of objective in that way, and it's looking at, I mean, I'm anthropomorphizing it now, but it's not sort of like held back by the emotions that you have as an individual or your limitations from your perspective. And it will say, in this framing, both parties to the transaction or whatever would have a shared responsibility, and therefore you can make the case that it would be more beneficial to do X. And it might be something that I hadn't thought of before. So I could see litigators at trial in appellate courts and judges using it in just the way that Adam's suggesting.
Yeah, I agree completely. I mean, one of the things that it does well, that everyone will say this technology does well, is idea generation. We do a lot of idea generation at the AAA around hard questions and hard problems. But now we always have the help of our LLM friends, and it is just really stunning how many ideas it can come up with and how quickly. And so it sort of makes sense that in trying to decide a hard question that two parties disagree about, it's going to be an excellent new tool in thinking of new solutions that nobody has brought to the table. So I really do think there's an exciting future for this technology and resolving disputes.
Very cool. And, I think it was clever that Judge Newsom used a concurring opinion to sort of lay out how he used this. It didn't impact the ultimate holding, but as you said, was an invitation to think about how LLMs could be used. And on the heels of all the stories about it, I met a judge at a conference recently, and I asked him because I was then curious about judges using generative AI in their opinions. And we talked about whether judges would need to disclose that they are actually using Gen AI. And people in the conversation had different perspectives on that. One perspective being that you would have to disclose usage so that appellate courts would know when the human judge created content and when a Gen AI created content. It all makes me wonder, though, if we'll look back on this era as sort of like the dawn of all of this, and it will become so infused in what we do that it will seem sort of laughable down the road that we thought we would have to disclose things like that. But I wonder what your perspective is on that topic.
Yeah, I think I understand the judge's reaction that you spoke to, even if I don't share it. It is important in appellate litigation for the appellate court to have the information that the trial court had when it made its decision, if it's going to be able to evaluate it properly. But I'm not sure that it makes sense that disclosing your use of the technology in the course of your decision making as a trial judge really follows from that. I mean, we don't trial judges don't, record what work exactly their law clerks did, to help them with coming up with a particular decision in a case. They don't disclose, what previous, work of their own that they might have done in some other context, and they're using it for this particular case. They've already researched this question in the context of a different case. They don't disclose, what Westlaw or, other legal research tools that more and more have this technology built into them. So I don't know that I agree with the conclusion, even though I understand where it's coming from. I think your prediction is correct that, I don't know, 5 years, 10 years from now, we should replay this conversation, and it'll seem a little naive at the front end of all of this.
Thank you for tuning in to 2030 Vision, AI and the Future of Law. If you enjoyed this episode, please subscribe to our podcast and leave a review. Stay informed and inspired as we continue to explore the AI-driven future of the legal profession. We'll see you next time.